For instance, if the opponent wields a knife, responding with a knife or less lethal means is generally acceptable, but using a gun may not be. There is a very famous court case in Korea where a man in his 20s was found guilty of excessively beating a thief who broke into his house. Hello, this is your attorney, Jiwon Lee. Today's topic is self-defense in Korea. In real-life situations, sometimes a small dispute escalates into a huge fight, even leading to an assault or bodily injury case. This can happen to you too, so I'll summarize everything you need to know about self-defense in Korea. This might save you from real trouble, so stay focused. Here are some examples. You fought back after some guy next table at a bar initiated an altercation by hitting your face. Therefore, hitting him back is considered self-defense. Second case. Upon discovering a thief breaking into your home and attempting to escape, you catch and injure the thief to prevent the theft. Third example, faced with a person attempting to stab you with a knife, you disarm the attacker and, fearing future harm, reluctantly stab and kill the person. Among the three examples, how many cases do you think are acceptable as self-defense? Unfortunately, those three cases are all found guilty under the Korean law. Let's find out why. Article 21 of the Criminal Code defines self-defense as an act performed to defend one's or another person's legal interest from imminent unjust infringement. Self-defense in Korea means that while physical force is used to counter an attack, it is not considered an offense if the act is deemed reasonable. This is known as the defense of legality, where specific circumstances can lead to a declaration of innocence. You have to remember there are three major conditions for recognizing self-defense in Korea. First, the principle of proportionality in using force. Second, the presence of the attack at the moment of defense. And third, most importantly, that it should be defense against attacks. First, the principle of proportionality is quite easy to understand. For instance, if the opponent wields a knife, responding with a knife or less lethal means is generally acceptable, but using a gun may not be. This principle applies across various scenarios, from traffic incidents to assaults and, in extreme cases, even to homicide. To easily put it, eye to eye, hands to hands, knives to knives, and so on. Second, the presence of the attack means the defense should be made at the scene. Therefore, retaliatory acts based on past events or anticipated future actions do not qualify as self-defense. Third, the defensive nature of the self-defense. This is the most controversial condition, and this is why there is a significant gap between public perception and legal interpretation. The major problem is this one. Let's suppose I'm under attack. Someone is hitting me or trying to stab me with a knife. How can I define what action is defensive or not at that very instant moment when someone is trying to hurt me? Wouldn't I just react according to my instinct to protect myself? Unfortunately, the judge always assumes that you are a very ordinary, rational, law-abiding citizen without any major defect, no matter how stressful the situation you are in at the time of the incident. Well, this seems too much to ask to an ordinary citizen, but that's the problem we are facing. For example, there was a news article about a woman stabbed boyfriend who assaulted her, and the court sentenced her to 10 months because the court ruled her action was not self-defense. The scope of recognized self-defense in South Korea is relatively narrow, with a focus on defense against attacks. It seems like the legal framework was established when Korean society was relatively safe, and this might have led to the current conservative application of the court. Now, can you understand why the three examples I introduced were found all guilty by the court? Okay, let's review the three cases. First, regarding physical altercations. You fought back after some guy next table at a bar initiated an altercation by hitting your face. Therefore, hitting him back is considered self-defense. In a fight initiated by someone, responding with force is not considered self-defense. The court consistently views such cases as mutual combat, where both parties are engaged in a physical altercation, and self-defense is not recognized. Regarding home intrusion, upon discovering a thief breaking into your home and attempting to escape, you caught and injured the thief to prevent the theft. In the case of catching a thief in the act, causing harm beyond what is necessary for apprehension may not qualify as self-defense. The courts consider whether the level of force used was appropriate to prevent the crime. There is a very famous court case in Korea where a man in his 20s was found guilty of excessively beating a thief who broke into his house. The homeowner returned home around 3 a.m. and found the thief rummaging through drawers. Initially, the homeowner hit the thief in the face with his fist and then with an aluminum pole taken from a laundry drying rack. The thief was rendered brain dead and has remained in a vegetative state since the beating and dead in the end. The court found the homeowner guilty with a charge of excessive self-defense, citing that he used a dangerous object to attack the unarmed thief who was reportedly set to flee. If you look closely at the case, there are indeed some elements that imply the homeowner chose somewhat excessive measures to attack the thief. However, it is still questionable what measures could have been reasonable at that moment when there was not much information about the thief in the middle of the night. Third case, regarding disarming and subsequent harm. Faced with a person attempting to stab you with a knife, you disarm the attacker and, fearing future harm, reluctantly stabbed and killed the person. If an attacker is disarmed and subdued, causing harm afterward is not considered self-defense. The requirement is that the threat must be present at the moment of defense, and anticipation of future harm does not justify self-defense. We looked through the most important features of the right of self-defense in Korea. To summarize, you have to remember 3 major conditions for recognizing self-defense in Korea. The principle of proportionality in using force, the presence of the attack at the moment of defense, and most importantly, that it should be a defense against attacks. I hope today's topic helped your well-being in Korea. This is your attorney, Jiwon Lee. Thanks for watching.